Any commission members do have some? 4, wait for 5, 6. We need 8.
7.
Morning.
7.
We need 8, but we have 7 of them too. As would be tradition. You're always like, hold on, but folks are. Come over as a panel.
We have 23 participants.
No, we have a bunch of people on the attendee side. Tani, are you good to go? We,
Should we start with that quorum? Skip the minutes.
yeah. I'm just trying to see if anybody else has popped.
We live. Can you hear me?
They can't hear you. Oh, yes, now they can hear you. Sorry.
Good morning. Can you guys hear me okay? Anybody's virtual?
Yes.
Thank you.
Yeah, so we can hear you.
Thank you, guys. We're one short on the quorum. We're trying to get that in place. We're gonna wait another couple of minutes. If we can't get that in place, we will skip the review of the minutes and go into some of the other subcommittee reports. So bear with us just a couple of minutes, if you will. Thank you.
And
No.
she's a nerd. She's not coming. She's got a nerd. And we have an attendee raising his hand. Demetrius Johnson with the Federal Office of Child Support Enforcement. For him to speak, I need to promote him to a panelist, but he hasn't accepted that quite yet. So let me. me check.
You
Okay, okay, here we go.
got it.
Yeah, we're gonna give it another world.
I believe he's going to be on listen only mode. I think that was a mistake for him when he raised his hand.
Oh, got it. It was got it. And I'm gonna ask Judge Connor via chat to come over and.
Seeing the new season.
That's what I like.
There's a scene in it where the one woman at the table, Carrie Russell's character, the men, and she's trying to get control of the chair, and she's trying to speak up, but she's trying, and one of the other men at the table says, "See, Miss So-and-so told us this. It is not appropriate in this day and age to have furniture that the women don't fit in."
Right.
And like, somebody get her a chair that'll work, and somebody,
Yeah.
and that's how I feel sitting in these chairs.
Yeah, these chairs.
Chairs
They're
are,
low.
they're too low, they're meant for like a 6'4" man and like maybe no one else.
5 to 6 issues.
Could you possibly?
We'll go get
invite
this,
Judge
phone book
Connor
set on.
to
But
accept-
that's what they did in the TV show, they put
Never mind.
the little
He's doing
sign.
it.
Of course, in this day and age,
Now, does that give you
nobody younger than me knows what a phone book is.
Still waiting.
Shall we start? Respect for that.
That's the part of growing older I didn't expect, is how obsolete I was become.
Yeah, I remember when the phone book is what you grabbed when anybody needed a little boost.
Yeah, yeah.
We're at 7. I'll let you know as soon as we get to 8 crossing.
All right, good morning, everyone, commission members and guests. Appreciate you joining us. We're still one short for a quorum, but we're going to move forward out of respect for those who got here timely. Don't want to hold you up too much. So welcome. Appreciate you being here. I'll turn it over to Latonia for housekeeping rules.
Good morning, everyone, and thank you for joining today's commission meeting. I'm Tom Lawrence, the program coordinator for the Georgia Child Support Commission. And I will briefly discuss a few rules that help us navigate the meeting today and the Zoom Thursday. The Child Support Commission meeting members and staff are designated as panelists within Zoom and can speak at any time during this meeting. All other participants are designated as attendees and are muted during the meeting, but may type a message in the Zoom chat feature if needed. Also, anyone wishing to give public comment by speaking today may do so at the end of the meeting after the completion of our agenda. Please state that you would like to give public comment by typing your request in the chat. Once you're called upon, we will unmute your audio, or we will unmute your audio. Our chair, Judge Key, will make the determination on how many minutes you are allowed to speak. In conclusion of today's meeting, staff will post this recording on our YouTube channel, Georgia Child Support Commission. And I will place that YouTube channel in the chat for everyone later. Thank you.
All right, so we'll come back to item 2, the review and approval of minutes, and go to item 3 on the agenda, the business of the commission, starting with subcommittee reports. And Dr. Federer, we'll start with economic subcommittee.
Right, thank you, Dr. Key. And the subcommittee last met on the 11th of August of 2023. So we haven't really had any activities over the past couple of quarters. We will begin looking at the 2026 economic study and ramping up for that in early 2025. This concludes our report at this time.
Thank you, sir. Any questions, comments? Thank you, Dr. Tutterow. We'll go next to Statute Review Committee. Judge Williford is involved in a murder trial, cannot be with us today. So I'm sure that Katie's going to do an amazing job in covering both of them. Katie?
Thank you, Judge Key. The Statute Review Subcommittee last met on October the 3rd of 2024. Two subsequent meetings had been scheduled for September and October. However, we were not able to achieve quorum and thus were precluded from conducting business. The next meeting is scheduled for December 2nd, 2024. The purpose of that meeting will be to discuss any cleanup to OCGA 19615 following the passage of Senate Bill 454. If there's anything that the commission members believe should be addressed within the statute, please let us know and we can discuss it at our next meeting. Admittedly, our agenda is already quite full, especially since we've tried twice now to meet and not achieve quorum, but still, we'd rather have a full meeting, especially once we get quorum or even a longer meeting. So please do go ahead and let us know if there's anything you see in the statute. I would like to bring to the commission a possible amendment to 19615 to state explicitly what I think is already implicit, but you know, there's a difference in legislative language versus case law that the changes brought forth in Senate Bill 454 constitute a substantial change in circumstance authorizing a modification of an existing order. In other words, allowing parents to bring a modification action as a result of the significant changes in our child support guidelines. So that's an issue I'd like to discuss with this commission today. Continuing with our report, the commission staff has continued to conduct an educational campaign regarding the changes brought forth by the statute. They are working hard, including most recently presenting at the ADR Institute, which took place yesterday, which I've already heard through the grapevine was terrific. So there's that. And then Judge Williford and I recorded an informational video explaining the usage of the parenting time formula tool and provided examples of the tool's usage. And that video has been uploaded to the commission website. I am speaking in 2 weeks at a CLE that is hosted by the Georgia chapter of the AAML, American Academy of Matrimonial Lawyers. It'll be at the State Bar. And I've got I think even a longer slot than normal. I think I've got like an hour and a half or something to go through this. And my understanding is the pre-registration has been really good. So we're getting the education out there. So other than the issue I want to bring before the commission, that is the Statute Review Subcommittee's report.
Well, let me say first, if I may, that again, we appreciate all the work you guys did. Everybody did on a 454. Our subcommittee staff and all the people that worked on that. It's amazing work. And also I've started watching the video that you have on, and you guys doing a great job on that. We appreciate that a lot. When I tried doing it, working my way through without it, not so easy. So we appreciate you guys doing the heavy lifting to make it easier for us. And as always, we appreciate staff and all that they do. So let's take this in order. One is from any commission members, is there any cleanup that you have on mind and on your mind now that you can share with Katie, so you don't forget once you get back to your day job and get it out. So any cleanup from 454? Right, hearing none. Katie, you want to talk a little bit more about,
Yes, so, so as y'all know, the current iteration of, 19615, even with the, 2024 legislative, changes, it does not specify whether those changes constitute, or justify or, prohibit or, they don't really speak to a modification and whether those changes themselves warrant the modification. And of course, our statutory scheme has always had some language about when a modification is important, and when it is not, and just historically, and don't necessarily quote me on this, but I'm in the ballpark, and Regina can probably correct me if I get the details wrong, but when we passed our income shares model, and went to that model, which was other than this 2024 change, was the last really sweeping change to our child support guidelines. We put in some sort of caps and floors on whether the change itself could constitute a modification. This time we have not spoken to that at all. Of course, the trouble with that is that, I'm getting asked pretty regularly, and I imagine staff is too, when we are doing education on this, well, does the change itself constitute a reason to modify? So my personal opinion, not speaking on behalf of the commission, since we've never discussed it and we haven't stated an opinion, but my personal opinion is that it does, because the whole reason for the parenting time adjustment and the low income adjustment for that matter is that we were impacting, in particular, non-custodial parents in an economic way that was not consistent with the underlying economic basis of our whole scheme. And we're trying to sort of, for lack of a better way to say it, right or wrong. And so to say that those who are caught in the window and had an order entered before it was fixed don't get a remedy seems, a furtherance of a wrong. I would argue even potentially a constitutional problem. So I think it does, but we also know that judges in particular like clarity, and, they start looking for things like statutory construction and whether it was in there specifically. And since it was in there specifically when we changed the guidelines back in, 06, I worry that, that we're going to force some litigants to force, or to, push a case through to the appellate courts, needlessly. And I'm worried that there's going to be a court or two out there who's going to say, well, if they'd meant for this to be a modification, they would have said so. We don't get to put our thoughts into the statute and say, oh, by the way, PS, here's why we did this. So, I mean, obviously we do know that, if you took a statutory, drafting class in law school, which I did, that you can go back and find that legislative history and it is persuasive, but that's a hard thing to do for a non-custodial parent who's just trying to get the economic relief that the legislature has said they're entitled to. They just got divorced or legitimated or did whatever, in the window where Georgia hadn't gotten up to speed. So I think we should ask the legislature to clarify that.
so before I open it for questions and comments, so we're talking about perhaps 3 years, and specifically, one is the changes in the economic table itself, cost of child rearing, one being going from a deviation to an adjustment, and the third one being ahead of my mind and just
The low income.
the low income deviation. Are those the 3 areas you're primarily talking about?
Yes, though I believe the change in the basic, in the BCSO table, actually, I actually think we did clarify that. Well, I think the statute as it was written already had language that when a final order is entered, it has to use the then pending guidelines. I don't know the exact language of it, but I think there is some language about that. I don't think that was new to Bill 454. If I'm remembering correctly, I mean, I don't quite have 19615 memorized, although some days I feel like I dream about it. But I think the changes to the table are covered because a final order has to be entered using the code on the day of the final order. So I think just that requirement that was there before sort of takes care of the BCSO table. It's why we've been telling people in our education campaign that if they completed, for example, if there was a pending case that was pending before July 1st of 2024, but isn't finalized until after, and they already did child support worksheets before July 1st. They do have to redo them in order to have the proper child support worksheets attached to their final order post July 1st of 2024. And that source, so I think that one's covered. So I really think it's really the two pieces, the parenting time adjustment, deviation to adjustment, and the low income deviation to adjustment.
I'm not sure how much difference it would make, but to clarify, my question was if someone child support had been set already and finalized 18 months ago,
Mhm.
Would adopting the new tables give them the basis to seek a modification without any other change?
We remain silent on that.
Okay.
Yeah.
But is that one of the areas though, that you think should be?
Potentially.
All right, so certainly with two of those items, and anybody that wants to can speak to the third. Commission members, any questions or comments?
I have a question. So I guess the question is more so for Katie. So are you suggesting that how far back would it go, what you're saying, in terms of a person being able to modify based on the new guidelines? Are you saying as far back as possible, or just between the time of the passage of the bill and when it takes effect?
Oh, no, I'm talking about any order. I don't think we can limit it to any current order, any current obligation for child support that did not take into account the statutory changes should be subject to modification. That doesn't mean a modification is going to be granted. Doesn't mean a modification is appropriate. It doesn't mean everything would still have to be analyzed just like it would for every other case, income, expenses, health insurance, et cetera, et cetera. But I think every current order.
But to be clear, Katie's not talking about retroactive modification of child support.
Correct. Yes, that is an important clarification. Yes, no, I'm not suggesting a retroactive modification of child support. We do have lots of law, black letter law, case law, and statutory law that says we don't do retroactive child supports, and I'm not suggesting for a second we open that can of worms. All right, I'm just talking about getting past the threshold of can I modify?
So the question is whether adoption of the 454 makes the parenting time and adjustments of a deviation, whether that statute in of itself is a substantial change of condition to allow us to seek a modification.
Correct.
Any other questions or comments? Thank you, Christina. You guys. And may I speak to it?
Please.
Okay. I don't know if that decision is ultimately ours. I think it's a very important public policy issue that the legislature should speak to, not us. I do think it's an important enough issue that we give them the language that they should consider. So I would like to see us prepare some language that would accomplish what you're talking about, and then the legislature can make a decision whether or not to do it. Anybody want to speak to that suggestion?
That is essentially what I'm proposing. You just said it better.
And I don't think that's not going to require a vote. I think that's something I can just ask the subcommittee to do, right? No, does not require a vote. Yeah.
No, that's fine. We can.
Okay, so I would ask the subcommittee to draft a language to submit to the commission to give to the legislature as at least a starting point. All right, thank you for that.
Sure.
Anything else?
Yeah.
My last chance for questions or comments directed to Katie. Appreciate your work. Technology and Calculator Committee, Regina.
Thank you, Judge Key. The Technology and Calculator Subcommittee last met on October the 18th, 2024. And speaking of the parenting time formula tool, the subcommittee at that time recommended that the tool be added to the current calculator homepage. It was already on the commission homepage, and commission staff have accomplished this request, and that was just to allow practitioners and judges immediate access when they were doing the calculations without having to go back into the actual administrative homepage of the commission. I'll come back to the calculator modernization project in just a moment to discuss that, but The subcommittee is also discussing a suggestion to have uninsured healthcare expenses on the basic information worksheet tab of the calculator auto-populate to line 3. That is the pro rata shares of each parent, which is spelled out in the code, still allowing the calculator users to change the value. And what we're doing based on that suggestion on the front end is before we bring something to the commission as a whole, we're going to draft some language as to what the calculator would look like to clarify the law, what the law is and is not right there in a little pop-up help box there if it does auto-populate. So the subcommittee is still working on that, and we appreciate Katie Cannell coming and passionately presenting her position on that issue to the subcommittee. It was a lot of fun to have her there. We have, however, tried not to make too many changes of that nature while staff has been working on the modernization project. It does continue to move forward towards a deployment time of January 2025. And again, staff has had the marching orders to make the calculator modernization as similar as possible in look, feel, and functionality. And I think you'll be pleased in what you're about to see. The commission staff, we've been busy sort of testing the new calculator, and upcoming, I think next week, if the timeline holds, we'll hear about that, more of that in just a moment. They're going to be contacting outside stakeholders for calculator testing. And so if anyone on the commission would be interested in assisting with testing, please let the commission staff know, and you can be added to the testing group. I've asked staff, rather than just this being an abstract, to actually present to the commission as a whole what this will look like. So they put together, I think, a brief slideshow presentation. Is that right, Kirk?
Yes, that is right.
All right, take it away.
All right. And LaTonna, if you can load that PowerPoint. Great. Go to the next slide. You can go to the next slide. Great. One back, LaTonna. There we go. So this should look fairly familiar to everyone. This is just a basic information worksheet tab. Again, to what Regina was saying, it looks very similar to our current calculator. It looks more modern, just a bit cleaner, but functionally, it is going to stay the same. But this is pretty much exactly what it's going to look like. I think they will be increasing the font size just a little bit on all of the lettering, but that's essentially what it'll look like. And LaTonna, if you'll go to the next slide. This is what Schedule A will look like. You know, once again, looks very similar to what we've got. It's just a bit updated and I think looks a little bit cleaner. And that will show you, this is Schedule E. I think Schedule E looks quite a bit better. This does look, you know, a bit more different, but it's a little bit less, you know, blocky. But yeah, this is what it will essentially look like. And on the last slide, we've got the search folder page. And once again, very similar feel, very similar look, just a little bit cleaner and more modern. And that is all we've got on it so far. I will say the one of the things that the IT staff and the vendor are working on is the original example of what the actual worksheet would look like. We had to request that they redo that because it looked too dissimilar from the current worksheet. So if you've got a print version of it, we wanted it to look as much as possible like the current worksheet looks, as to not kind of confuse anyone. So they are working on that to make it look as similar as possible.
So Judge, realizing that lawyers and judges are change resistant, all change is inevitable, I'm afraid, in terms of upgrading our technology, and it will look a little different. But in terms of a timeline, the test environment should start next week. Is that right? Start next week through December the 9th with, if all goes well, a production week ending January 13th for that replacement to be up and running January the 17th. If the timeline holds, and we have every reason to believe based on what the testing looks like now that it will. So we'll be happy to try to address any questions from the commission or other staff members.
Anyone have questions for Regina, either from staff or commission members?
I do want to add to, just in case anyone's thinking about it, they will be doing a data migration while we're sending it out to the outside stakeholders to do testing. They will be doing data migration, so all of your worksheets, you know, it should be assumed, but all of the worksheets will be in the new calculator. So you won't have to redo anything; they'll all still be there. So
They'll look different.
they'll look different, yeah. They'll be there.
Is there gonna be any public awareness around this so that lawyers don't just open them up and see something
Yes.
different, get scared,
Yes,
or judges for that?
it will be.
I want to tell a joke I told in 2006 about judges, but I won't. In my last meeting, I will. Any other questions for Katie? Does that take care? I mean, I'm sorry, for Regina, does that take care of it? All right, thank you so much. All right, that gets us. Still in quorum. Still in quorum.
We're still right at 7.
Right. So we go to item 4, new business. This is permanency plan, deviation and dependency cases. And I'm just gonna make a quick remark about it and then hand it off to Noel. I think it's planned.
Yes.
So this issue revolves around ordering and collecting child support from parents whose children have been in foster care. It's in a sense for the cost of that foster care, both during the dependency of the dependency case and afterwards. And I know for those who've been around a while, remember the child support started, child support division child support services was called child support recovery. And that was most of what it's all about.
And then
And has-
enforcement.
then
and then
enforcement.
services,
Oh.
yeah.
All right, so Noel?
Thank you. Okay, so we thought I'd just take a moment to orient everyone to this issue because we have some experts on juvenile court dependency cases with us, of course, our beloved chair, Judge Keyes, juvenile court judge. We also have our colleague at the AOC, our CIP director, Diana Johnson, and we have some of her federal counterparts. So we're very lucky to have those experts with us today, but others, their expertise lies elsewhere. So as Judge Key was saying, the discussion focuses on ordering parents of children in foster care to pay child support to the state of Georgia to offset the cost of their children being in foster care. And so from time to time, staff is asked to present on child support to juvenile court judges. For instance, over the years, at their request, we've presented to DeKalb juvenile court judges, Hall County. Most recently, I was with the Council of Juvenile Court Judges to present on the new case styling for the child support worksheet that they requested and to present on the passage of SB 454. And invariably, when I'm presenting, a discussion will bubble up organically amongst the judges themselves on whether or not it's appropriate to order child support in dependency cases. And there's a range of opinions there, and they often ask my counsel. And I've shared really the only official guidance I've ever seen on this topic is a joint letter from the a joint letter from July 2022 that I believe Kurt sent you all by email. It was issued jointly by federal officials at the Children's Bureau and the Office of Child Support Services. It addresses the issue of when it's appropriate for the Title IV agency, which in Georgia we call DFACS, to secure an assignment of rights to child support for a child in foster care. It discourages across the board policies that automatically require an assignment of rights. In fact, they go so far as to say it should be done, and I'm quoting, only in very rare cases. The letter goes on to describe the issue of child support as referred from the 4E agency, that's DFACS, to the 4D agency, DCSS, to pursue child support payable to the state. So that single issue is taken out of the dependency case and run through DCSS's normal channels. The letter advocates that this should be done rarely and only after a thorough review of the case, and only if it won't disrupt reunification. That being the child in foster care with their parent. The letter goes on to cite two main reasons for this. One, they argue it can negatively impact a family's economic stability. They cite a Wisconsin study that reunification plans that are implemented in these cases often create additional costs for parents, such as parenting courses or therapies for the family. And tacking on child support in addition to those new costs could possibly delay reunification, keeping children in foster care for longer. They also argue that this practice is not cost effective for the state. In other words, it's not what the cost incurred by the state to pursue and enforce child support exceeds what they recoup. They specifically cite an Orange County, California, and a Washington State study. The California study found that for every 41 cents recovered, $1 was spent in the effort. Similarly, Washington found that for every dollar spent, only 39 cents in child support was recouped. So they're advocating that automatically pursuing child support is detrimental to children. They close out their letter by offering help to state agencies. They direct those agencies to contact their local Children's Bureau regional offices, and they offered federal funds to help change computer systems that make that referral a default. And then Kurt's worked on securing experts at the federal level. So they're on and prepared to answer questions if you'd like.
All right, so to those experts that Curtis lined up for us, do you have any general comments you want to make first before we entertain questions?
Good morning. My name is Diane Kelly, and I am the Regional Program Manager for Region 4 here in Atlanta. Region 4 covers the 8 southern states for child welfare. We also have in listen-only mode the program specialist that supports Georgia for child welfare, and also the child support regional program manager, as well as the program specialist that supports the child support side. I think you guys recognized Demetrius earlier. Pretty much the letter that was just summarized would have been my opening comments. I'm certainly here to answer any questions that you all have. I will add that a few weeks ago, I was able to sit in on a presentation of Georgia DFACS's new child support referral policy 9.12, which did a really good job. Just real kudos to Georgia DFACS in supporting the reduction of referrals to child support for children in the foster care system. It's a policy that I feel is very well developed. It gets to the spirit of what we were trying to do, which is to recognize that child support for children in the foster care system who are eligible for Title IV-E, that indicates right in itself that these are families that are impoverished and likely have come to the foster care system because of their issues related to poverty. I'm here to answer any questions. If you all have not seen Georgia DFACS's new policy 912 that changes how child support orders are determined, I certainly hope that someone present can speak to that. But I'm here to answer any questions that you all have.
and I personally have not seen that. I don't know if, commission members have. Is it anyone that can summarize that for us? Because apparently that's George's new position on it.
Judge, I don't know that I can summarize it for you, but I can certainly send the policy around to the commission members. And it's not, that's the DFACS piece of it, referral policy sort of simultaneously, child support, the Division of Child Support Services. That was the child welfare policy, I think, that Ms. Kelly was speaking to, that she sat in on the educational meeting for all sort of a system-wide educational meeting a couple of weeks ago, but there's corresponding procedure in the Division of Child Support Services, ERG procedure 339. I'll also send that around, as well as the child welfare manual policy she referenced. So everybody can look at the details. It's not short and some of it's technical. So it may or may not be something that applies to what you do, but if you have any questions, of course, you can reach out to me, and if I can't answer them, I can connect you with the appropriate person in the agency that can answer your detailed questions about it. But it appears to me that they got it right in putting forth policy, and if folks will follow the policy, and we will all be in good shape, I think, in terms of implementing the letter as well as the spirit of the letter that was referenced, the dear colleague letter of July 29th.
Now, before we go forward, anything that you wanted to say before we answer any questions? Any position on any of this that you want to talk about?
Just that quickly glancing at the policy, it does the most important thing that I've heard among judges and other colleagues, in that it takes away the automatic cases to child support and makes it discretionary with some, looks like really good guidance to determine when or if it is appropriate to seek child support.
And I think I alluded to this when we talked previously, that there's state law, there's federal guidance, there are all sorts of things that you have to thread the needle on as an agency. But I think there has been some perhaps work around, I'll say this, around 1911-6, which makes clear that the recipient of public assistance is deemed to have made an assignment to the department versus what that referral mechanism looks like once you're sort of implementing that responsibility that's provided by the statute. So that's where the work has been. That's where the emphasis has been in response to the letter. So we'll get that out to everybody, and hopefully, I think they've done the work, and they have landed the plane, but everything can be improved. So,
I do have a question.
yes.
Is there anything in this policy that prevents that referral for child support going directly to the Superior Court rather than putting it into the hands of the juvenile court judge, which is another thing that's a lot of expressed, being more appropriate?
So the referrals are to Superior Court in the division. That's where they operate. They don't operate. Once a referral is made to initiate a case, it will be a Superior Court action. And I think that dovetails into what Judge Key perhaps had in mind in discussing the policy around increasing the role of the juvenile court in handling that issues. Is that correct, Judge? Is it? So it is, from the division standpoint, that is Superior Court apparatus.
Any questions for either Ms. Kelly, Ms. Johnson, Regina, from the commission or staff?
Yes, I have a question.
Noel?
Do you think there's any value then in the commission possibly reaching out to the Council of Superior Court Judges in terms of communication and just presenting on the issue, making those judges aware that when they get sort of a batch. How I believe it's done is they get like a batch of cases, and the dependency cases are not flagged in any way. And so they would think that that's just a typical run-of-the-mill situation when it may not be. So that's a possible workaround or step toward what I think you're getting at, which is a Superior Court judge who has no familiarity with the underlying dependency case is suddenly making a ruling just on child support. That could greatly, affect the dependency case. So, I mean, for instance, there's a deviation specifically for this situation. Of course, right now, I'm forgetting it's either called parenting plan or foster care plan.
It's a reunification.
A reunification, it's one of those, I should know, but I can't remember at this point. I would imagine our Superior Court judges really wouldn't know necessarily that would apply in those cases. I mean, there could be an educational effort made there. I'm not sure how often, if ever, that deviation would be used in Superior Court. I don't think the DCSS SAG is necessarily raising it.
So I will just say, at the risk of overstepping the commission's statutory wheelhouse, which is the child support guidelines statute, that the division in its enforcement and collation is a separate chapter of Title 19. It has separate provisions in it, including there's no jury trial in established, about the sport and administrative aspects to it. So if there were something legislatively or policy wise to be done, that would be where you would want to do it if you wanted to create a different path or a different parallel path, for lack of a better word, in terms of juvenile court involvement in those cases. I do think that from what I have seen of the child support aspect of the policy, they are now generating the reports where perhaps those cases could be flagged and indicated, at the risk of somebody yelling at me later for saying that, something I didn't ask somebody about before I got here. But I do think the reports are being generated about the referrals from DFACS, so that internally the division is keeping up with it. And then, of course, that has to translate to special assistant attorney generals and court personnel and case numbers that nobody sitting here has any control over, and that also the division doesn't have any control over. But those are all, I believe, the moving parts of what would be necessary to segregate those cases for some sort of parallel track or additional treatment or coordination, for lack of a better word.
Judge King, you may know this off the top of your head. Statutorily, is there a mechanism, say you were successful in having those cases flagged and recognized in Superior Court? Is there a mechanism for referring child support cases to juvenile court in the same way that there's a mechanism for custody determinations to the juvenile?
I don't think that there's not a specific provision just for child support. Other issues can be transferred when the custody case is transferred to the state. They're not specific to child support. This is a very large, the intersection of child support and child welfare is important. It's complicated. It's become more complicated, in my view, in the last few years, because either statewide or certainly significant pockets of that state of Georgia, Department of Family and Children's Services has done an exceptional job of promoting family preservation, doing all they can to keep families together instead of separating them. And one way to do that, and the juvenile courts have the authority so long as they have jurisdiction over the case, is to order the non-custodial parent to support the custodial parent. Because so many of these cases, it's the failure of the custodial parent to be able to maintain a safe and stable home. They're receiving no child support, and they really struggle. And creating that stream of income is important and can help stabilize the family and avoid removal of the children from the home. One way to do that was through the referral process before, but theoretically, once the child's in state custody, this assignment is made and Child Support Services would seek to recover child support. What I've seen very little of this, but it's out there. I hear about it. What I've seen, in 2 or 3 cases is that somehow, even though it was referred through that process, the reunification deviation was not considered or given. But on the other hand, you do have that non-custodial parent. And if you create that stream of income that initially flows to the department, that could then flow to that custodial parent. When the dependency gets over, that would be great, but none of that infrastructure is currently in place. So if we just totally stop the assignment of the benefits, then we lose that opportunity to collect child support from the non-custodial parent. Right? I know I've had recently, because I haven't seen that much before, but even this week, I had a termination of parental rights case. And one of the grounds for termination, a separate ground that also established an abandonment in 1511-2, was not paying court order child support. But the child support order, the mother was not even present when it was ordered. They imputed minimum wage and calculated child support with no deviation, and she was ordered to pay that child support. And now, she has that as a grounds against her in the termination. I refuse to consider it because it was more than she could have afforded to pay. So I'm not going to hold it against her since it's more than she could have afforded to pay. That's one issue, right? And the other is the legislature previously felt it good public policy to allow us to order parents to pay child support while they're seeking reunification, but under some reduced amount. And some of us used the low income deviation as a kind of a max, and some of us went even below that or above that, but in that range. So there needs to be a discussion around that, because that's currently the law, is that we have it in place and we should deviate, but it doesn't always work. So my initial thought around this is really a training issue from superior courts and to Division of Child Support Services. But it's really a much bigger issue than that, I think, much bigger issue than that. I know that, I'll just say this publicly because I got in trouble with some friends about it. As this article that was in the paper, some of you may have seen, and I was quoting the article, never should have talked to him, but I did. And it's in my view that whoever and however it happens, we should never order a parent to pay child support that impairs the ability of that parent to maintain home with their children, however that happens. So you also have the issue of child support arrearage, which in that case was about child support arrearage. So we may have done away with ordering child support now, but these arrearages are built up. And that article talked about some states have just waived the arrearage in those cases where the parent was ordered to pay child support while the child is in foster care. So that's an issue that has to be dealt with in some way as well, right? I felt so stung by that article, as a matter of fact, that I got a call recently from one of our Atlanta TV stations, wanted to interview me about drug testing and dependency cases and accountability boards. I refused to talk to them.
Yeah, that's one
Okay.
question. I think I know the answer. I just would love to hear it. Is there any reason to think that Georgia is any different than the states that Noelle referenced, when she was giving us the update, that have actually done studies about things like the cost benefit of seeking collection versus how much they actually recover? Any reason I think Georgia's an exception? I mean, I can't imagine there is, but
Well, there would be, but yeah.
I mean, we're operating under the assumption that this is a Georgia problem and there's no expert or educated person who thinks that we should say, oh, no, not Georgia. We collect, 1.5 times, what we spend on it, right? Surely.
I don't know, but I could not think of a reason why we would be any different. I can't imagine that collecting child support under these circumstances
Is any easier here than it is anywhere else.
winds up in much in the black.
That's right.
And Judge Brunt has been able to.
Yeah, okay. Judge, is he? Oh, yeah, he's actually Judge Brunt. Welcome.
Thank you. I was actually able to listen to everything on the phone. I had a hearing in Gordon County this morning. I was traveling back, but I was able to listen to the previous conversation. So I'm president of the Council of Juvenile Court Judges. I'm not speaking on their behalf, though. This is sort of my opinion. We have had discussions about child support in various council meetings, though. I do agree with that letter. I certainly agree with everything that Judge Key says. Judge Key has forgotten more about this issue than I know right now, so I defer to him on a lot of this. I do think that it can be very detrimental to reunification when there is a child support order in place for most of our parents. But I also think there needs to be some system in place to collect child support against those parents who are not working the plan, or with the older teenagers. We have several cases here in Bartow County where parents have basically just gone to DFACS and said, here, take my child. I can't handle them anymore. And in those cases, I do believe a full-fledged child support order is more than appropriate. And I've been frustrated sometimes by the delays in that occurring, the referrals being made to Superior Court. We do, at least I think I have the power to enter a full child support order if someone makes a request in my court, but in the 8 years I've been serving as a judge, I've never had the department seek child support. I'm not criticizing them for that. The various reasons have already been explained about why that doesn't happen. But each case just sort of stands on its own. But for most of the parents that we have are of limited means, of limited education, limited work skills, limited ability to earn income, although they can certainly do that. But they need every dime they have to either acquire suitable housing for reunification, or every dime they have to make other arrangements to have their home ready for their child to return. So it can be extremely detrimental in those cases to have a child support order in place. I don't know if there's any way to flag cases that go to Superior Court when there is juvenile court involvement, where at least maybe the SAG or the court could reach out to juvenile court just to inquire about the status of the case so they could have that information in hand. But that's pretty much all I have to say right now.
So, Judge Brunt, thank you for logging on, but the problem is I've forgotten so much. That's kind of the problem. People think that's a compliment, but what would you think about, do you think your dependency committee of the council would welcome the opportunity to consider these issues that you've raised and we've talked about here? Review the new practice of policies from the state, these things Regina referred to, and provide comment to the commission?
I think so. Yes, I certainly speak with the head of the dependency committee, Judge Altman and Judge Wyant, and discuss this with them and see if they'd be in a position to make recommendations.
Yeah, I think as chair, I'd have the authority to give you the opportunity to do that. So that would be my request, because I'd love to have the input from the council as judges. I suspect there'll be some different opinions around that as well, but it would be very valuable for us in terms of trying to address these issues. I would love to find a way to be supportive of the family preservation that the department's done such a good job on, and keep that alive. Again, if I do order child support frequently against the non-custodial parent under our jurisdiction who is not really working a reunification plan. And the most clear direction of the case is the child will be back with the custodial parent. Problem is, when we get that in place, when I return custody to the, not custody, when I close out the case, conditional custody case, then that order goes away under current law. Because we cannot order a support order beyond the jurisdiction case, likely case. So.
Yeah, I mean, from what I understand about the way this referral process is operating in these policies, if a parent is refusing to engage in case planning and reunification efforts, there's going to be a referral. And there's just no way to deal with, to Judge Brunt's point, a parent who is not going to engage in trying to be a productive part of their child's life and to take care of their responsibilities. So I don't think even the new policies certainly don't affect that scenario.
And I would certainly need to review the policy. My sense was if we were complying with the letter of the spirit, I mean, the spirit of the letter of July 29th, 2022, that we would order child support recovery. I'll use that term because that's really what it is. in only limited circumstances. Is that our current, the new policy?
Again, with those exceptions, there is now a very detailed process that, the, case workers on the defect side have to go through to assess the family circumstance to make the referral in the first instance. And of course, none of this ties the hands of judges to do as they see fit and enter the orders. And those orders that come to the Division of Child Support Services directly from juvenile court judges or superior court judges are going to be enforced.
Thank you, Chief.
Well, Judge Key, the other complicated factor that I have in this child support scenario with kids in foster care, I mean, when you do have cases that are rare, when you do have, middle class, upper middle class parents who are subject to these orders, to my knowledge, there's no system in place where if someone's paying $1,000 a month in child support, where that can help the child that's in foster care. There's nothing extra that child gets because the parent is paying some high amount of child support. Because I think all that just goes to the state, or at least that's my impression of how that works. We have to do something where the child could also benefit from the payment of the child support when it is more than just this standard, when it is more than the amount necessary to offset foster care expenses.
I don't think there's anything urgent. This is not an action item for us today, I don't think. I think what we need to do is to see what Judge Brunt can do through his counsel. And we can all get familiar with these documents that Regina's sending out to us and maybe revisit again at the next meeting. Does that suit everyone? I think it's a very important issue, but again, very complicated. And thank you all, our experts who joined us today. And Judge Brunt, I'm not saying that you're not an expert, but you're not listening.
That's fine.
All right, so the next item is the subcommittee assignments. That we can talk about, I'll be glad to. All right, yeah, on the subcommittee assignments, I think it's good from time to time to revisit our makeup. We do it on the commission when our term's up, where we consider for appointment, either reappointed by the governor or not. Some people sign up on our subcommittees, and even the commission itself. And reach a point where does not meet where they are in their life for various reasons, because life gets in the way. It is very important that we're able to have working members of these committees. I tell people all the time, the real work of these kinds of organizations is done in the committees. It's the same in the Council of Juvenile Court Judges that I've been in for all these years, and it's the same here as well. Major work is done in our committees and subcommittees. And we need people on those subcommittees and committees that have the commitment, the passion, and the time. Again, life changes over time, and the time to do it. So maybe we want to revisit our committees. And if you're on a committee and you don't feel like you can make the commitment to make most of the meetings, then that's fine. Just let us know. No, we don't draw any inference from that. We appreciate your service anytime. But Kurt, are you gonna go over the list of committees or what
Yes,
committees
sir.
we have?
Sure. And I'll be happy to send out this list as well, so everyone has a copy of it, but quickly for the economic subcommittee, we do have 4 members. We have Dr. Roger Tutter, the chair, Charles Chuck Clay, Representative Houston Gaines, and a non-commissioned member is Jill Massey. For the technology and calculator subcommittee, we have Ms. Regina Quick, chair. We have Senator Emmanuel Jones. We have Anna Bolden. We have Judge Warren Davis, and we have Jacqueline Fortier. For the statute review subcommittee, it's the biggest one. We have Katie Connell, co-chair. We have Judge Connie Wilfred, co-chair. Judge Lisa Colbert, Representative Chuck F. Strachan, Senator Emmanuel Jones, Judge Michael Key, Judge Emery Palmer, Ms. Regina Quick, Christina Scott, Senator Brian Strickland, and our non-commissioned members are Sarah Austin, Patricia Bonadonna, Byron Cuthbert, and our newest member, Shawnita Gooseby with the AG's office. And I'll be happy to send out this list to everyone as well, so they have a hard copy of it.
A question, do we have to have a quorum in the subcommittee to do work and bring forward, report out, I think we do. So would it not also would it not make more sense to have smaller subcommittees? So that you know that you're gonna get a quorum?
Your lips to God's ears.
Okay, and because there's nothing that says that a commission member can't attend other subcommittee meetings. They can speak, they can share input, they can take assignments from that committee chairman. But it would almost seem to me you want a smaller official committee where you're confident in 50% quorum.
And I've seen variations of that. I have seen committees where you have voting members and non-voting members on the committee, and sometimes that can get your quorum better. That's certainly a good idea. Another option, and I reviewed the law on this, and certainly the commission, then a majority is the quorum. Does not speak to subcommittees. I don't know if our bylaws speak to subcommittees or not,
It does.
but another option would be to amend the bylaws to reduce those required for quorum. All those are good ideas. And I have no preference. We just need to resolve it.
And on the latter point, ultimately, everything comes to the commission.
Right.
So whether there's a quorum or not on the subcommittee level might be less important because they have no true power independent of the commission itself. So
maybe the solution would be a combination of some of these. If someone really wants to work on the committee, they can stay on the committee and work on the committee. But then we could maybe entertain by a voice vote to reduce the quorum in our committees and subcommittees to something less than 50%. We can't even vote on that today.
Speaking of quorums.
But we can't do an electronic vote. So I don't know why this proposal could not come from one of our members. If staff puts an amendment to the bylaws together, then and gives it to a member to make, we have an electronic proposal or the motion and a second. Some commission member need to move it.
I will move. I will move that we amend our bylaws such that subcommittees do not require 50% attendance to accomplish quorum for voting purposes.
Could you put a percentage on that? What's your suggestion?
Let
Based on your
me
experience?
think about my last two. See, ours is the largest committee too, which is
By a lot.
right by law.
By
And so that's so any percentage could potentially be problematic for us.
Well, but that can be accomplished without affecting the work of the other subcommittees. That could be accomplished by handling the composition of your subcommittee.
Right.
And in everyone's defense, everybody wants to hang out with Katie Cannell and Judge Williford and discuss the law.
Right.
Everybody does, but it also is the main work of the subcommittee, the intensive work that you all have done over the last 2 years has inflated the number of bodies necessary to do the level of legal work that's been done on the statute.
Right.
So perhaps it could just be assessed at this point to reset.
Right. I agree. I think that's an excellent suggestion. So in terms of a percentage for my motion,
Or we could just.
or we could assess we could do either one. I'm open to either. I just think we need to do something because we're getting stuck in the mud.
We're gonna be able to vote today anyway, right?
True.
Chuck's trying to log in, but he had no get out of the meeting.
We
You
could-
have to, sound crazy, but do you have to have a quorum? I mean, if you could have a meeting called to order by the presiding chairman.
So I would propose this, if it's okay, so the staff think this through.
Yeah.
I think you guys remember zero-based budgeting? I think it's President Carter, zero-based budgeting. So maybe we have kind of zero-based committee assignments and we'll send out a notice to all committee members asking who wants to sign up again for committees there. No, we don't
Opt in.
appoint for any particular term.
I like that.
And if those that apply for it, then I'll make the appointments with input from staff based on that.
At the end of that email, let's please point out to people, you're free to attend any subcommittee meeting. You're free to do all the work you want on the issue. But if you can't be at the meetings, it's better not to appear on the committee.
I'll do that, and then staff can think about, and maybe in response to that, what it looks like when we know the numbers of these committees, what percentage we might go with if it's less than 50%, so.
I feel like that might not even be necessary, like we maintain our typical 50% quorum and just address, because right now, well, we have today as an issue, but it's rare that we don't achieve it at the commission level or at other subcommittees, which are much smaller. Also, a lot of, you know, like I believe all 4 of our legislators are on the committee. They're very, very busy.
Yes.
We have,
Yeah.
I think all of our 3 Superior Court judges who are obviously very busy. But if they can attend, to your point, Dr. Tadaro, please do when you can attend. But by being officially on the committee, it hinders quorum and then hinders the work. I don't think anybody wants that.
The first step does not require a vote. It's not an action item for the commission would be my request to you that you send the letter out to all committee members asking them to be reappointed to the committees.
Well, Judge, and I want to reiterate to everybody who's a participant on this meeting, the members of the public are always welcome at subcommittee meetings. That's why we send the notices. That's why we give the notices. We had a member of the bar show up to the last technology and calculator subcommittee meeting, just showed up, and I permitted him to fully participate in the discussion in the same way that I allowed Katie Cannell to participate in the discussion as a commission member. So if somebody wants to work, there's plenty of work to go around.
Do any of our any commission members participating virtually today have any comment about any of this? We don't want to exclude you just because you're on the screen. So,
I'm not seeing anyone.
thank you all.
Our
Cool.
guest, Diane Kelly, had to log off, but she thanked us for the invitation and she's happy to attend again if needed.
Thank you. We have any public comments? Anyone signed up for public comment?
Not yet. I put something in the chat asking that folks who wish to make a public comment, type their name in the chat and they'll be called upon, but nobody has thus far.
Judge Keegan, do we need a motion to approve the minutes and then agree to take the votes electronically? Or do we wait till the next meeting?
Judge Key can just direct us to do it electronically.
Yeah. And I know you've got to run. So thank you. Before you go, I do want to announce, the only thing left to schedule the meeting after that is that, I'm going to appoint Judge Bulford as co-chair of the commission. We haven't had one, in a while, and, I'm going to appoint her as co-chair within my authority to do that.
Does
I
she
feel like
know?
everyone would agree with that.
Or is that because she's not here today?
Because she's not here today.
Monitoring the screen.
That's what happens. No, she knows. I've had not had a direct conversation with her, but she knows. Thank you for being here, Dr. Tadaro. The
Thank
only
you.
thing
Happy
left,
holiday call.
right, thank you. The only thing left would be schedule the next meeting. It's not like like last year when we anticipated having meetings about legislative matters. Is there a time frame that you're thinking about that we need to have?
Do you want to have a meeting around, do you want to, do you anticipate an e-vote amongst your, that's something, maybe we do an e-vote and so no action in person or this, or hybrid.
See what it looks like.
But yeah, let's see what maybe we can start by instead of calling for an e-vote, calling for e-discussion. And that can tell us if there's going to be, because if there's a bunch of discussion, then maybe we need a meeting.
And that typically is like that 5-day waiting period is to foster discussion. We don't really have discussion
Right,
about
right.
the minutes or whatever,
Right.
but sure. And right, if it gets too crazy over email, we could call.
Right.
Oh, and hold on, we are getting, oh.
I'll probably be more flexible myself next year with meeting times. I'm no longer be sitting full time on the bench. Mike, can you make a statute review committee meeting, Katie?
We have another member of the public, Mr. Raja Anton, just made written comments in the chat that we can note. He says at the very macro level, here are his initial thoughts on child support relative to foster care cases, and then he goes through them. So we can just note them and
We send them out to the committee.
yeah, we can send them out. Or if you'd like me to read them right now, I can do that.
How long do you say?
It's not very long.
Yeah, let's do it. So, I don't know if anybody in the public's with us, any guests, but Let's just go ahead and get in the record. Just
Sure.
read it.
And then it'll be, yeah, great. Okay, so this is from Mr. Raja Antone. This is him speaking. It perplexes me. Oh, sorry, this chat thing is. finicky. It perplexes me how duality is present in so many aspects of life. In one scenario, the system is concerned about the impact of that child support will have on the ability of the family to coalesce and operate synergistically. So the narrative on the surface sounds like we're okay with the state not, oh gosh, sorry, this is jumping. We're okay with the state not being paid child support because we want to position the family for an opportunity to reset and stabilize. But we don't show the same grace and understanding when the father, the non-custodial parent, would have to pay child support to the mother custodial parent. These discussions, like all others, have alarmingly little input or engagement from those who actually carry the burdens, the parents, especially the non-custodial parent or payee. There really needs to be more representation and advocacy in that space.
All right, well, thank you for that, and we'll certainly make that part of our record, and anybody doing work on this will make that group aware of your thoughts.
Do we want to go ahead and schedule, the first meeting of the new year? Just so that we have something on record if we need to meet again sooner, have like an emergency meeting or something, we
Yes.
can do that, but go ahead and actually have one set.
Yes, good idea. Let's try to do that. How far out would that be?
It's in March or April.
Great date. Well, if we put it towards the end of March or early part of April, kind of in the middle.
Yeah.
So. I don't know where.
Because we may want to consider scheduling something toward the middle of March, wrong around crossover day of the legislature. It's usually,
If
That
there's
time
anything's
frame.
come up, that's when we'll.
Is that too late? To just really focus on what's crossed over, you're saying? So,
if we're going to schedule a meeting in March anyway, maybe that fourth week or third week of March.
March 21st. 10 o'clock here, well, and virtual.
Sound good?
So we'll set our next scheduled meeting for the 21st of March at 10 o'clock. It will also be virtual, although one of these days I'd love to have everybody back in person. But we'll schedule this one virtual. And again, we
Virtually
may,
only,
no, in person virtual.
hybrid.
Hybrid, I'm sorry, hybrid.
That's okay.
Hybrid. And be aware, we're gonna have some activity on electronic votes probably, and perhaps another in-person or another hybrid meeting before then, but for certain, we'll schedule count on March 21st at 10 o'clock.
All right.
If y'all get the notice out there as soon as everybody get on their calendars. All right, anything else for the good of the order? All right, thank you all for joining. We stand adjourned. 11:15. It says it right here.